Padilla v. Kentucky, Supreme Court, 2010. Justice Stevens delivered the opinion of the court. Petitioner Jose Padilla, a native of Honduras, has been a lawful permanent resident of the United States for more than 40 years. Padilla served this nation with honor as a member of the U.S. Armed Forces during the Vietnam War. He now faces deportation after pleading guilty to the transportation of a large amount of marijuana in his tractor trailer in the Commonwealth of Kentucky. In this post-conviction proceeding, Padilla claims that his counsel not only failed to advise him of this consequence prior to his entering the plea, but also told him that he did not have to worry about immigration status since he had been in the country so long. Padilla relied on his counsel's erroneous advice when he pleaded guilty to the drug charges that made his deportation virtually mandatory. He alleges that he would have insisted on going to trial if he had not received incorrect advice from his attorney. Assuming the truth of his allegations, the Supreme Court of Kentucky denied Padilla post-conviction relief without the benefit of an evidentiary hearing. The court held that the Sixth Amendment's guarantee of effective assistance of counsel does not protect a criminal defendant from erroneous advice about deportation because it is merely a collateral consequence of his conviction. In its view, neither counsel's failure to advise petitioner about the possibility of removal nor counsel's incorrect advice could provide a basis for relief. We granted certiorari to decide whether, as a matter of federal law, Padilla's counsel had an obligation to advise him that the offense to which he was pleading guilty would result in his removal from this country. We agree with Padilla that constitutionally competent counsel would have advised him that his conviction for drug distribution made him subject to automatic deportation. Whether he is entitled to relief depends on whether he has been prejudiced, a matter that we do not address. 1. The landscape of the federal immigration law has changed dramatically over the last 90 years. While once there was only a narrow class of deportable offenses and judges wielded broad discretionary authority to prevent deportation, immigration reforms over time have expanded the class of deportable offenses and limited the authority of judges to alleviate the harsh consequences of deportation. The drastic measure of deportation or removal is now virtually inevitable for a vast number of non-citizens convicted of crimes. Changes to our immigration law have dramatically raised the stakes of a non-citizen's criminal conviction. The importance of the accurate legal advice for non-citizens accused of crimes has never been more important. These changes confirm our view that as a matter of federal law, deportation is an integral part, indeed sometimes the most important part, of the penalty that may be imposed on non-citizen defendants who plead guilty to specified crimes. 2. Before deciding whether to plead guilty, a defendant is entitled to the effective assistance of competent counsel. The Supreme Court of Kentucky rejected Padilla's ineffectiveness claim on the ground that the advice he sought about the risk of deportation concerned only collateral matters, i.e., those matters not within the sentencing authority of the state trial court. We, however, have never applied a distinction between direct and collateral consequences to define the scope of constitutionally reasonable professional assistance required under Strickland. Whether that distinction is appropriate is a question we need not consider in this case because of the unique nature of deportation. We have long recognized that deportation is a particularly severe penalty, but it is not, in a strict sense, a criminal sanction. Although removal proceedings are civil in nature, deportation is nevertheless intimately related to the criminal process. Our law has enmeshed criminal convictions in the penalty of deportation for nearly a century, and, importantly, recent changes in our immigration law have made removal nearly an automatic result for a broad class of non-citizen offenders. Thus, we find it most difficult to divorce the penalty from the conviction in the deportation context. Deportation as a consequence of criminal conviction is, because of its close connection to the criminal process, uniquely difficult to classify as either a direct or collateral consequence. The collateral versus direct distinction is thus ill-suited to evaluating a Strickland claim concerning the specific risk of deportation. We conclude that advice regarding deportation is not categorically removed from the ambit of the Sixth Amendment right to counsel. Strickland applies to Padilla's claim. 3. Under Strickland, we first determine whether counsel's representation fell below an objective standard of reasonableness. Then we ask whether there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. The weight of the prevailing professional norms supports the view that counsel must advise her client regarding the risk of deportation. Authorities of every stripe, including the American Bar Association, criminal defense and public defender organizations, authoritative treatises, and state and city bar publications, universally require defense attorneys to advise as to the risk of deportation consequences for non-citizen clients. In the instant case, the terms of the relevant immigration statute are succinct, clear, and explicit in defining the removal consequence for Padilla's conviction. Padilla's counsel could have easily determined that his plea would make him eligible for deportation simply from reading the text of the statute, which addresses not some broad classification of crimes, but specifically commands removal for all controlled substances convictions except for the most trivial of marijuana possession offenses. Instead, Padilla's counsel provided him false assurance that his conviction would not result in his removal from the country. This is not a hard case in which to find deficiency. The consequences of Padilla's plea could easily be determined from reading the removal statute. His deportation was presumptively mandatory, and his counsel's advice was incorrect. 5. We have little difficulty concluding that Padilla has sufficiently alleged that his counsel was constitutionally deficient. Whether Padilla is entitled to relief will depend on whether he can demonstrate prejudice. The judgment of the Supreme Court of Kentucky is reversed, and the case is remanded for further proceedings not inconsistent with this opinion.